Hello, my name is Chris McDonald, an attorney at Birch, Dewitt, Kolash & Birch, and I would like to talk about restrictions on amending claims in a reissue application as the issue arose in the recent CAFC decision in Antares Pharma v. Medac Pharma. In this case, Antares appeals the lower court's decision to deny a motion for preliminary injunction. The motion was denied for lack of showing of likelihood of success because claims added during reissue were likely invalid for violating the recapture rule. As the court noted in the decision, an applicant is free to claim any subject matter in continuation and divisional applications during normal prosecution of an application as long as the claims meet the enablement and written description requirements. However, claim amendments in a reissue application are also subject to the recapture rule and original patent requirement. The standard for the recapture rule is set forth in North American Container decision discussed in section 1412.02 of the NPEP. Simply stated, limitations in the claim added by amendment or specifically argued as defining the invention over the prior art cannot be broadened during reissue. The claim can be broadened, but the limitation added or argued as being the basis for overcoming a prior art rejection cannot be broadened. In the present case, the original patent was directed to a needle-assisted jet injection device. Claims added during reissue do not recite a jet injector, but recite injection devices having safety features, such as a latch, push button, or needle guard. Antares argues that the claims are directed to an overlooked aspect of the invention and therefore avoid the recapture rule. An example of an overlooked aspect avoiding the recapture rule is an application that discloses two methods of ion implantation in glass and originally claims the use of a molten bath and the particular pressure and temperature are added by amendment. A reissue application claiming the second method of plasma ion implantation would not violate the recapture rule, as the limitations regarding the pressure and temperature are not applicable to the plasma ion method. Antares asserts that the reissue claims are directed to an overlooked invention, thereby avoiding the recapture rule. However, the court notes that there is the original patent requirement that is roughly equivalent to both the written description requirement and the prohibition on new matter. All three basically require that the original patent specification disclose the particular invention now being claimed. The specification must clearly and unequivocally disclose the newly claimed invention as a separate invention to satisfy the original patent requirement. In this case, the court looked to the title, summary of the invention, and repetitive description of the present invention as being a jet injector in concluding that the disclosure of the safety features now the subject of the reissue claims were only ancillary to the single disclosed invention of the needle-assisted jet injector. So, when does an application disclose two inventions? That is a question answered only after considering the patent as a whole. Certainly, when the patent discloses two alternatives to a method, step, or feature, such as the two ion implantation methods discussed earlier, one method could be considered an overlooked aspect when only the other is originally claimed. Another example cited by the court arose in the case of In Re Amos, which disclosed two different methods of raising rollers as they approached the end of the table. Therefore, reissue claims are restricted not only by the recapture rule, which arises during prosecution of the original claims, but also the original patent requirement, which arises if the disclosure does not clearly and unequivocally disclose the newly claimed invention as a separate invention, which arises during preparation of the disclosure. Both requirements should be considered before deciding to proceed with the reissue application. Thank you for joining me today. Please stay tuned to BSKB.com for more updates regarding interesting intellectual property decisions.